All right, I'll start over. This morning we're going to talk tort law. I have a lot to say this week about that, and so I think the way I'm going to do it is I'm going to lecture today and Thursday, and then we'll have a quiz due next Monday just based on what we talked about this week. And then next week I've got a little bit to lecture on, but we'll spend most of next week on discussing some things, cases, and having our discussion and that sort of thing. It's just going to take me 2 days this week to get through the lecture on torts. So you will have a quiz this week, but you don't have any assigned reading this week outside of just the lecture outlines and the key terms. There's an Easter egg in the key terms. There's an Easter egg in the lecture outline. So make sure you find those. So today we're starting on tort law, and it's been really kind of 2 weeks on that. And to give you just sort of an overview of that, we talked, remember, about how we've got a body of law that's criminal law, and then we've got a body of law that's civil law. So tort law falls within civil law. So we're living within civil law for the next couple of weeks. Torts is a subset of civil law. Torts gets confusing sometimes because the same act could result in a crime, but also a tort. We talked about how O.J. Simpson's murder case landed him. He caught some criminal murder charges for that, but he also got sued by the family for the tort of wrongful death. All right, so these next 2 weeks we're speaking in terms of tort law and civil law, not criminal law. Torts are defined as wrongs against others in the civil sense. Wrongs against others in the criminal sense fall under crimes. These are wrongs against others in the civil sense. Tort law exists in order for an injured party who has suffered some sort of loss or damages to have a way to recover for those from the person who caused them. All right? In criminal law, to contrast for a second, remember that the purpose of criminal law is to punish the person who the wrongdoer, to deter other people from committing the same acts, to protect society. Tort law doesn't necessarily care about those goals. Tort law cares about getting the person who's been injured or wronged compensation to make them whole for whatever their loss is. All right, I could be speeding down University Avenue on the way to class with my eyes closed and slam into the back of another motorist. I'm very likely to catch some criminal charges for both traffic and maybe some other serious ones, but that doesn't help the person that I ran into. The person who I ran into wants their car fixed. They want any medical bills that they have paid, and they want to make sure that they don't have to come out of pocket for anything that I caused. Purpose of tort law. Okay? So even if I have that big wreck on University Avenue and the police come and they charge me, the person that I hit is also going to want to sue me under tort law to recover for their loss. We call the recovery in tort law damages. Damages means the money award that a judge or jury gives the injured party. Damages can come in different forms. So your outline talks about compensatory damages and punitive damages. We'll break those down a little bit. Compensatory damages do just what they sound like. They compensate the victim or the injured party for their loss. We can break compensatory damages down into a couple different categories. We can break it down into special damages, which is usually defined as damages that we can prove and calculate. There's a receipt for it. My hospital bill was $20,000. I can show that from the hospital billing records. My car cost $5,000 to repair. I've got the auto body shop's estimate or their bill to me or even better, the canceled check that I wrote them to show where I have paid them to do the work. Those are special damages. My lost wages. If I'm an hourly employee, I missed 3 weeks of work, I'll work 40 hours a week. I made $20 an hour. It's $40, 40 hours times $20 times 3 weeks. Special damages can be calculated. General damages are also to compensate the victim or the injured party, but there's no calculator or formula for general damages. These are things like pain and suffering, loss of a limb. If I'm in a wreck and I lose my arm, I'm going to want to be compensated for the rest of my life of having to live without that arm. We can't go on the internet and look that up. It's one of the few things that we can't look up on the internet. There is no calculator that you type in, this guy's a lawyer, he's 53 years old, he does this, this, and this, and he lost his right arm. How much is that worth? We don't even know how much longer I'm going to live. I may live a year. I may live 50 more years. All right? Those are going to be decided by the judge or the jury. So there would be some evidence put on at trial. If I'm proving my special damages, my evidence is the hospital bill, right? My evidence is my employer coming to court and saying, Tebow's paid hourly at $20 an hour. He usually works 40 hours a week. That's my evidence on that. My evidence on pain and suffering is probably going to be me testifying as to how awful it was, maybe having my doctor testify to all the different things they're treating me for, maybe have my therapist testify as to how this has affected my life, maybe have my wife testify as to how I was before versus how I was after. But again, the jury or the judge are going to have to take all that information and put a dollar amount on it. General damages. Punitive damages are less common in tort law, but they do exist. Punitive damages come into play when the defendant's actions were so egregious or objectionable that we feel like punitive damages would be appropriate because they would send a message to others not to do this as well. Take a example of a products liability case against an automobile manufacturer. All right, let's say that I was driving a Ford pickup truck. It flipped, the cab collapsed and crushed me and my passenger. My passenger died. I was injured severely. I'm going to sue Ford because I'm going to allege that their design of the cab was defective, that there was something wrong with the product that caused my loss. It didn't perform the way it should have. All right, and let's say that at trial, I'm going to ask for compensatory damages, sure. My hospital bills, the loss of life, companionship of my passenger, all those things. But I might also ask for punitive damages if I can prove, or if it comes out during the case that Ford knew that there was something wrong with this design, and they made the decision to go ahead and produce the truck that way anyway. If we didn't hit them with punitive damages, then Ford's thinking and other companies' thinking going forward might be this. Well, yeah, there's some defective with the design of our cab, but we're probably going to sell X billion dollars of this. Of that, we'll have a few lawsuits of which we'll have to pay out, X. If we recalled the truck or stopped production, we would lose this amount. So actually, from a bottom line perspective, we're fine with being sued a couple times and having to pay for it. We're still going to come out ahead financially by going forward with this. If a jury says not so fast, Ford, how about in addition to the couple $100,000 in compensatory damages that you owe this victim, we're going to say that you owe $4 billion in punitive damages. Is that enough to make you stop doing this in the future? Is that enough to make you think twice about the next defective design that you have that you're thinking it may just let it ride and pay the cost? GM, Hyundai, Jeep, all these other manufacturers, they see Ford getting hit with the $4 billion in punitive damages and think to themselves, maybe it's not worth it for us to just take the risk of having this defective product. So punitive damages do come into play. They're not as common, obviously, as compensatory damages, because compensatory damages is the whole point of tort law. We can split torts up into intentional torts and unintentional torts. Today's lecture is all about intentional torts. Thursday, we're going to talk about negligence, which is an unintentional tort, which means I didn't mean to cause the harm that I did, but I still did and I'm responsible for it. And my victim's got to be compensated for that. Today is all about intentional torts. So we're going to see different torts. We're going to see the definition of them. And within that definition would be the different elements that you'd have to prove if you went to court and sued somebody for that particular tort. Intent is an element of all the ones we're talking about today. If intent is not present, then you would not be able to prove that tort. It doesn't mean you get away with it or that you're not responsible for compensating the victim. It just means that they've got to sue you under a different tort in order to get compensated. They can't use an intentional tort to do that. Okay? Intent. I'll walk up to Drew and I take a swing at him. Okay? If I connect and he ends up losing a tooth, did I intend to swing at him and hit him? Yeah, that's an intentional tort. If I open the door normally after class and somebody's walking by and I slam the door into them, I didn't intend to hit anybody. If I was careless and I should have been more careful, I still might be at fault. But that would be the unintentional tort of negligence, meaning I wasn't as careful as I should have been. Thursday is all about not being careful. Today is all about intentional torts. Look at the tort of assault for a second. The first two we're talking about today are assault and battery. And as you hopefully have learned by now, words in the legal context sometimes mean different than what we use them in this normal language. We tend to think of assault as like beating the hell out of somebody, right? Getting in a fight, something like that. If you read the definition of assault, though, you'll see that it is an intentional, unexcused threat of immediate harmful or offensive contact, such as words or acts that create in another person a reasonable apprehension of fear. That's an assault. If I walk up to Drew and I act like I'm going to punch him and I stop, I didn't hit him. Can you make the argument that I've committed assault as it's defined in your outline? Yes, Autumn says yes. How so? Prosecute me. Prosecute is a criminal word. Sue me for that.
Because you intentionally tried to make him think you would harm him.
Yeah, there you go. Good. Was my swing intentional? Yeah. Was it a threat of immediate harmful or offensive conduct? And did it create a reasonable apprehension or fear of harmful contact? Yeah. If my 3-year-old niece comes up to Drew and shakes her fist at him, is that a reasonable apprehension of fear? It depends on how mean she is, right? But probably not. Is it reasonable for me to be afraid of a 3-year-old? If my 3-year-old niece is waving a gun at Drew, then does that become a reasonable fear? Pretty fast, it did, didn't it? Okay. So we tend to think of assault as actually getting in the fight or causing the contact. Assault is just the fear of it. If Drew is turned around and let's say he's at the pencil sharpener. I can't believe we have a pencil sharpener. That's like so old. That is funny. He's at the pencil sharpener and I walk up behind him and clock him in the head. Who wants to be my lawyer and argue that I have not committed assault? Can you defend me, Garrett? You can't? Who can defend me? Seth, defend me. Look at the definition again. What is in that definition that he can't prove for assault? I meant to hit him. Absolutely meant to hit him. Yes, Autumn.
He didn't expect to get hit, so he wasn't afraid.
That's right. I didn't create any reasonable fear of apprehension in him because he never saw it coming. That doesn't mean what I did is okay. It just means that it's not assault. All right, so when we see all these definitions, this is where people get frustrated with lawyers. Like you're getting all picky on these words and stuff. Like, well, yes, that's how it works. So I might not have committed assault on Drew, but I did commit the next tort of battery. Battery is defined as an act that results in harm to the plaintiff. It's an unexcused and harmful, offensive physical contact intentionally performed. All right, again, we tend to think of this as fist fight, or I do. That's what comes to mind when we hear assault and battery. My daughter was telling me last week that there was a boy in her class who was, we call it snake spitting back in the day. Y'all call it something different, where you flick your tongue and it spits. You know what I'm talking about? What do you call that? There's a word for it. Gleeking. There you go. Gleeking. So this boy was gleeking on the girl in front of him and got her shirt all wet and she didn't know it. And I was thinking to myself, not assault, but battery? Is that offensive and harmful contact? Being spit on? Yeah, that's battery. So it's not necessarily like something that causes pain. Harmful or offensive contact. If I have an infectious disease that is easily transferable, I'm infectious. What's the word I'm looking for? Contagious. Thank you. I'm extremely contagious. And I run down the aisle and I touch everybody on their face and rub my hand in their face. I haven't really hurt anybody from a pain perspective, but is that battery? Do y'all want me to rub my hand all over your face when you know I'm highly contagious? No. So assault and battery can also go together. When I walk up to Drew and I take a swing at him and he sees it and I connect, I've committed both assault and battery.
You really want to beat me up there?
No, I don't. I'm picking on you because I know I couldn't kick your ass, and so that makes it a good example.
I think you got me.
I don't. I'm pretty sure I don't. I can guarantee you that. But I appreciate the compliment. So when I walked up and hit him at the pencil sharpener, that was battery, but not assault. All right. So assault and battery. I throw these out first because they're kind of easily conceptual, how we can see how we have to look at how a tort is defined and what would have to be proven in court. Another point I want to make to you is that remember that tort law is all about compensating the injured party. If I take a swing at Drew and miss, he could meet the definition of assault. He could go down to the courthouse and file a tort law case against me for assault. But when it gets time to prove his damages, he might not have any. I didn't actually hit you. You didn't miss any work. You didn't go to the hospital. It was embarrassing, right? That the teacher with the old man was swinging at you. You're embarrassed. But is that something that's compensable? Is that something that we can give you money for? Probably not. So I've committed the tort, but he's not going to sue me for it. We're not going to sue somebody. We're not going to go around today with a list, a notebook, keeping track of all the torts that got committed against us, and then going down to the courthouse tomorrow and filing court cases on them if they're not going to get us any money, right? Otherwise, it's a waste of time. So tort law is all about having the damages that need to be recovered or compensated for. Again, to highlight the difference between tort law and criminal law, I take a swing at Drew and miss, no damages, he's not suing me for a tort. Law enforcement might be pretty interested in that. We can't be having teachers swinging at students. He doesn't have any damages, but law enforcement might have an interest in prosecuting me for assault to punish me for that and to keep me from doing that again. If I'm Drew's parents and I find out that the business law professor took a swing at him in class, I'm going to want to know what law enforcement's going to do about that. If I'm that little girl's parents in school who's getting spit on, I don't know that I want him to be prosecuted, but I might like him to be scared on that. I don't know. Difference between criminal law and tort law. All right, the next one on your list is false imprisonment. This does happen in the business context some. False imprisonment is when you intentionally confine or restrain another without justification. If I stand here and if I lock the door and you all can't get out, and I intentionally lock the door so you all can't get out, that's false imprisonment. Again, got to have some damages in there if you're going to recover anything. If I pull a gun and say, no one leave this classroom, I haven't actually physically restrained anybody, but my threat has restrained you unjustifiably. That'd be false imprisonment. Again, these are all intentional torts. Let's say that we are here at night, that we had some special nighttime class for some ridiculous reason, and we turned off all the lights. It gets to be midnight. We're resting. The janitor comes by and locks up, doesn't know we're in here, wouldn't expect there to be anybody in here. There's no signs of anybody in here. That's not false imprisonment because it lacks the intent. So all of our torts today require some sort of intent. Intentional infliction of emotional distress. So this is an interesting one. Very hard to prove because the damages are by name emotional distress. If I, well, the example in your outline is that there is a automobile accident and the victim makes a claim to her insurance company that's legitimate. I need you to pay for the damage that was done to my car when I got in a wreck today. And the insurance company denies her on purpose, even though they know it's a legitimate claim. They delay on purpose, knowing that she needs all kind of medical care that she can't afford. They harass her friends and her family by calling them and sending out emails or saying that she's a liar and she fakes her injuries. Every time she talks to them, they make fun of her and tell her she's not getting anything. That kind of activity might support intentional infliction of emotional distress. It's got to be something that's extreme and outrageous. Intentional infliction of emotional distress. Torts are not exclusive. So in my example with Drew, I swung and missed. He's not limited in, if he's going to look at the menu of torts that are available to him, he and his lawyer, he's not limited at just picking one. He can pick as many as he wants that he thinks he can prove. All right, so he might pick assault. He wouldn't pick battery because I didn't actually touch him, but he might throw in intentional infliction of emotional distress. It's not a great case for that. But he could say I was so traumatized by the embarrassment to my classmates and everything of Mr. Tebow taking a swing at me that I had some severe emotional distress. Not a great case for it. But point being, you're not limited to one. You can throw in as many as you want. You've still got to prove them at trial, but it doesn't hurt. It doesn't cost you anything to add extra torts. Defamation. This is one that is very popular these days. Our president sues for defamation all the time or gets sued for defamation. The explosion, I think, in the way that we can communicate about other people just through social media and technology and all. I mean, it used to be that defamation would be if you said something bad about somebody or you wrote something and it got like published in a newspaper or it was on TV or something. Now, those things happen everywhere we turn. All right, so defamation is a false statement of fact that's published to a third party that harms somebody's reputation. So those would be the things you would have to prove. Defamation comes in two forms, two flavors. One is slander, which is spoken defamation. The other is libel, which is written defamation. I want to differentiate because my southern accent is going to say these two words the same, but they're not the same for our purposes. Liable is if you are responsible under civil law for the damages or the loss that you've caused somebody to incur. Liability. Libel is the tort of defamation in its written form. Libel. You could be liable for libel. Right? You follow me? You could be. Today I'm talking about L-I-B-E-L, libel. All right, so a false statement of fact is the first element. That means that what is the best defense to defamation? The truth. That's right, Ms. Cut-Kelvin. The truth is an absolute defense to defamation. It's not defamatory if it's true. I can shout from the rooftop something that's very bad about somebody, but if it's true, it's not defamation. It has to be a false statement of fact. It has to be about the plaintiff, the person who's suing you for it, and it has to harm their reputation. And then it has to be published. By published, I don't mean printed. Publication in the legal sense means that it was said or disseminated to somebody else. So if I call Garrett a cheater in front of the class, that's a false statement of fact. It's about him. It's damaging to his reputation. And I published it to the class by speaking it. He could sue me for slander, oral defamation. He's going to have a problem with damages, right? I mean, what are his damages really? But I've committed I've satisfied all the elements of the definition of defamation. If Garrett and I are in here after class privately, the door is shut, no one else is in here, and I accuse him of cheating, call him a cheater, that isn't defamation, because even though I've made a false statement of fact, even though it was about him, it was harmful, it was not published to a third party. If the door's cracked open and anybody walking down the hall heard it, then I've published it. Publication in the written form, libel, is much easier to conceptually. I mean, obviously, if I've printed it, if I've put it on my Instagram, if I've written it in a book or in an article, other people are going to see that. Publication is pretty easy is much easier to prove in libel than it is in slander. If the person who is being defamed is a public figure, famous person in the public eye, This is also a definition that has expanded over time, especially accelerated in the last 20 years, I would say. Who is a public figure? If the false statement is about a public figure, then those people have an extra element that they have to prove at court. They've got to prove something called actual malice, which means that the person did it on purpose and did it with the intention of hurting them, that they knew it was wrong and false and they did it anyway. And that's a trade-off that public figures kind of pay. They don't get as much protection against defamation as private citizens do. Sort of a trade-off for, look, you are by nature of being a public figure spoken about publicly. People talk about you. We can't really police every single thing that somebody says. Society sort of takes with a grain of salt what we say about public figures anyway. Whereas if I say something really, really, really bad about Seth, that's not the same thing. You could pull up any celebrity's Instagram right now and find really bad comments. When I told you that defamation is really a popular thing to sue for these days, I was doing some research last week and saw that the president of France, Emmanuel Macron, I think is his name, he has sued an American publication, I can't remember who it was, a newspaper, I think, or some media brand in America, for defamation for saying that his wife is biologically a man. Y'all seen this? You know where I was going with that? Y'all have heard, everybody see, you've already heard all that, right? It's Candace Owens. That's right. So y'all already knew about that. Yeah. So if Emmanuel and his wife are going to court, they're going to have to prove that it was false. They're going to have to prove she's actually a woman. Not that hard to do. They're going to have to prove that it was about her and that it harmed her. Harm, I mean, is that harm? Is that an awful thing to say? Yeah, yes, I'm not going to defend saying that. Does it harm her? You see why public figures get a little bit less protection? I mean, does anybody really believe that? The damages would be hard to prove, I think. But his point in suing, I guess, is just to stop people to prove a point that you can't just go around saying whatever you want to say. The guy who was, who's the Truth Wars guy? Alex Jones said that the Sandy Hook shooting was a hoax, and all those parents of those kids who died in that shooting sued him for defamation. And he refused to participate in the suit, and so the judge found against him for a pretty big sum. I think that was a defamation case as well. The 2020 election, there were a lot of defamation cases that got filed over that, like those poll workers in Atlanta who sued Rudy Giuliani for defamation. They won a verdict against him. The people who manufactured the voting machines, I think that was Dominion Corporation, they sued Fox, or they sued one of the media outlets for reporting that their machines were defective or had caused disparities in the voting, and that ended up not being true, and so they got a big old verdict against, I think it was Fox, I can't remember. Defamation. Defenses to defamation, as Autumn pointed out, are the truth. Another defense to defamation is opinion. All right, defamation has to have a false statement of fact. Garrett, you look like a cheater. Not necessarily defamation. Is that a bad thing for me to say? Yes. But he's got to prove that it's a false statement of fact. And I didn't actually call him a cheater. I'd say he looked like a cheater. All right, let's move on to invasion of privacy. So invasion of privacy takes some different forms. One is intrusion into an individual's affairs or seclusion. Any place that we have a reasonable expectation of privacy. If someone violates that without permission, or without a legal reason to do so, that could be invasion of privacy. Somebody breaks in my home tonight, a burglar. Are the police going to come and get them from charge them with some crimes? Definitely. But I also could charge them or could sue them for the tort of invasion of privacy. Am I going to do that? Probably not. But maybe if I can't recover some of the things that they stole from me, I might want to sue them in tort for this. And part of my damages would be, while you invaded my privacy, you took things that belong to me. And I need to be compensated for that. When you invaded my privacy, you broke my door. And that needs to be paid for. Eavesdropping, hacking into somebody's account, all those are examples of invasion of privacy. Georgia is states are differ in how they handle recording other people. So in Georgia, you're allowed to record you and somebody else, or you and a group of other people, without telling them. But you cannot record other people talking or communicating that you're not a part of without their permission. That would be invasion of privacy. But it is not invasion of privacy for me and Carly to have a conversation after class that I've recorded on my phone that she doesn't know I'm recording. But if Cody are talking after class, and I have secretly planted a bug or a wiretap so that I can hear what they're saying, and I'm not part of that, that is illegal. Invasion of privacy. False light means publishing information that paints a misleading or false impression about a person. It's very similar to defamation, but it's different from defamation in that defamation was the actual statement of a false fact. False light means I didn't say it, but I inferred it. Or I've placed you in such a way that other people might think that's what I'm saying, even if I didn't say it. Leandre, if I put on my Instagram page your picture and I write down under it, my caption is, I'm always on the lookout for cheaters. Okay? You probably don't have a defamation case because I didn't say you cheated. I didn't make that false statement of fact, but I sure inferred that you were a cheater, right? I made it look to everybody like you're a cheater, which of course you aren't. That would be false light. If somebody put up a picture of me on the wall on a poster and it said, it's like the health department puts out a poster that they put up in every classroom that says, educate yourself on the dangers of STDs. But it's got my picture on it. Okay, not defamation, because we don't have a false statement of fact, but we have false light. So long as what? If I sue the university for false light, Keyshawn, what's their best defense to that? What would make me lose my case? What would be an automatic win for CSU? Well, false light, you don't have to directly say. Defamation, you would. Right on, if it was true. Now, that doesn't necessarily get them off because it depends on how they found out, right? If CSU found out because they saw in my records from the health clinic. Do we have a health clinic at CSU? We do? All right, so I went to the health clinic to get treated, and that's a private thing. and then they've all of a sudden now put this out, that might be the next invasion of privacy on your list. Public disclosure of private facts. Facts that aren't public, but that are made public. That'd be like revenge porn, or the doctor releasing your private medical information. Public disclosure of private facts. Back to my example of the false light, if it's known that I have that condition and they put me on the poster and say, educate yourself on the dangers of whatever, okay, that's not going to be false light because it's true. It's not going to be public disclosure of private facts because it's not a private fact. So invasion of privacy takes different forms. You guys who are managers, Jace, Austin, you guys have to be careful about what you tell other employees about other employees. You have somebody that wants off because they have, I don't know, some terrible disease. You can't go around telling everybody that so-and-so's out today because they've got whatever it is, right? The last one on the list is appropriation. This happens in the business context all the time. This is using somebody else's name, image, likeness for commercial gain, for profit. If I post on Instagram a picture of Leandre and say, another satisfied student in business law, right? I didn't get his permission to do it, but I haven't really invaded his privacy because he's a student in business law. That's a known fact. That's not a secret. It doesn't put him in a bad light. I didn't make any money off of it. So not appropriation. But let's say that Leandre is famous and I make potato chips. I put Leandre's post in my business account a picture of Leandre saying, I love these potato chips. Leandre supports these potato chips. They're his favorite chip. Now I'm making money off him without his permission. That would be appropriation. Fraud. I will note that right here in the outline is a color for this week. So note that. Fraud is intentional deceit for personal gain. So the elements of fraud that we'd have to prove would be misrepresentation of facts with the knowledge that they're false. That misrepresentation has to induce another to rely on it. So think of it in the sales context. You come into my auto dealership, you ask me if this car has been wrecked. I know it's been wrecked because I wrecked it, but I tell you it has not been wrecked. That's a misrepresentation of fact. My intent in misrepresenting that is to induce you to buy it. There has to be justifiable reliance. Is it justifiable that a customer at a car lot would rely on the salesman's representation as to whether or not the car had been in a wreck? Yeah. They work there. They're the ones selling it. That's reasonable that they would know. Then there has to be damages. So if you come to my car lot, I lie to you about this car, you come really close to buying it because you relied on my representation, but you decided at the last minute not to buy it because you decided you couldn't afford it. You can't sue me for fraud because you don't have the damages portion. You didn't actually buy anything. Nothing detrimental has happened to you. We have to be careful in the context of fraud as well because there's a certain amount of sales talk and puffery, or it's hard to draw a line between fact and opinion sometimes in sales. So the line between fraud and just what we would consider normal sales can be blurry. All right, wrongful interference with a contractual relationship. Wrongful interference would occur when a third party knows that two other parties have a contract, a valid enforceable contract, like an employment contract, and they induce one of the parties to break the contract on purpose. That would be interference, wrongful interference with a contractual relationship. Let's say that Soraya works for me. She has an employment contract with me, and Ms. Hill knows that, but Ms. Hill wants to hire her away from me, so she goes and offers Soraya $20,000 if she breaks her employment contract with me and goes to work for her. That could be the tort of wrongful interference with a contractual relationship. If Ms. Davis works for me without a contract, which most of us do, well, a lot of us do. A lot of jobs are not contractual. Then Ms. Hill can go and try to hire her away all she wants to. If I'm the manager of Popeyes and I want Jace to come manage my Popeyes instead of the Chick-fil-A, do you have a written employment contract with Chick-fil-A? No, I can do that. There's no contract that I'm interfering with. Wrongful interference can also take the form of interfering with somebody's business. Like if I'm at that car dealership and Jada comes to buy a car from me and we're sitting down at the desk, she's about to sign the papers, and Keyshawn, who works at the dealership down the street, comes into my dealership, looks at Jada and tells her, don't buy that car from him. I'll give it to you for a lot less than that. Come on down the street with me. Well, I'll make you that deal. That might be the tort of interference with a business relationship. Now, if he stands out on the corner, not on my property, and advertises that he sells the car cheaper, that might not be wrongful interference. That might just be competition. I mean, the line is blurry as well when it comes to competition versus wrongful interference. Competition is not illegal, but it could cross the line to become wrongful interference if it gets taken too far. Those are the intentional torts against a person that I want you to be familiar with. The next category is going to be intentional torts against property. So these would be things that happen to things that we own, not our person. The first is trespass. Trespass does not require harm to the land. Trespass just requires the entry onto someone else's land or premises without permission. The entry doesn't have to be physical, meaning that I don't have to actually go into Miss Karin's yard to trespass on her property. I could do that by sitting across the street and firing a cruise missile into her backyard. Okay? I didn't set foot on her property, but I caused something else to do some damage on her property. That could be trespass to land. So it's when someone enters onto somebody else's land, causes something else to go onto their land without permission, and that causes damages. Now let's say that I've been hammering home the fact that damages would be important in any tort case because it would be pointless if we didn't have some sort of money damages to get. Not always the case. Let's say that that Aiden he takes a walk on a walking trail every single day, and he detours off the walking trail onto my property for about 300 feet. Okay, he doesn't cause any harm. I don't have to be compensated for that, but I want him to stop. I might sue him for trespass to land, And part of what I might ask the judge or the jury to do is to prohibit him from being on my land anymore. I don't want any money for it. I don't have anything that he's injured or harmed that I need to be paid back for, but I want him to stop doing it. So most of the time we want damages. Sometimes what we want is for somebody to stop doing something. Trespass to personal property. So this is a little bit confusing because when we think of trespass, we tend to think of physically being present someplace that we're not supposed to be. We can actually commit trespass to somebody's personal property by taking it or damaging it or preventing them from using or possessing it. So, Drew, I walk by right now and I take your phone and put it in my pocket for the rest of class. I didn't damage it. No harm I've done to it, but I did prevent you from using and possessing your own property. That's trespass to personal property. Again, when you think about people that want to sue for tort to make recovery, they might be looking at that menu of tort law and choosing all the ones they can. Doesn't hurt. Conversion is the next tort, and it is very, very closely associated with trespass to personal property. Conversion happens when you take or injure somebody else's personal property and then you keep it. So if I come by and grab Drew's phone and I walk around the classroom with it and I put it back within 30 seconds, I have trespassed against his personal property, but I haven't committed the tort of conversion because I didn't keep it to use for myself. Conversion is really trespass for an extended period of time. If I took Drew's phone and I kept it for a day, 24 hours, and he sues me, he's going to sue me for trespass and for conversion, right? Why stop at one? If I got in that auto accident this morning on University Drive and I rear-ended that person, I might catch some criminal charges, probably going to catch some tort charges for negligence if I did it accidentally, for some intentional tort if I rammed their car on purpose. But I'm also probably going to catch a charge for trespass to their personal property. I've damaged their car. Conversion would be like if I stole it, drove it. Trespass would be the actual harm and damage I did to it. They go together very often. Believing that you're entitled to the property is not a defense. So if you're walking down the street and somebody's like, hey, pops open the trunk, I'm going to sell you some PlayStations, that you could be charged with some tort of that if those PlayStations were stolen from somebody else and they belong to somebody else. If I pick up, I'm not going to use that example. We don't need to get too confused. Disparagement of property is the next one. And disparagement of property is it's very similar to defamation, but instead of saying something that's a lie about a person, you're saying something that's not true about a product or a business. It's defaming a thing instead of defaming a person. Disparagement of property. I stand out in front of Seth's hot dog food truck with a sign that says Seth's hot dogs are made from cat meat. Okay, I haven't defamed him, although it's arguable. I think if I'm his lawyer, I might be suing for defamation too. But I'm definitely suing for disparagement of property. I've made a false statement of fact against his product that is harmful and that was published to third parties. Same type thing as defamation. So disparagement of property is defamation of a thing or a business in much the same way that defamation is about a person. Okay, so that is everything I wanted to talk about on intentional torts today. Thursday, I'm going to talk about the tort of negligence. That'll take up the whole time. I will post a new outline for you on negligence before Thursday morning. You have nothing to read this week other than the outlines and the key terms. Your quiz next Monday will be over basically what we've talked about in class and what's on those outlines. All right, if you came in late, come see me. Keyshawn, I have something to tell you as well. Good luck at the career fair. Everybody go to the career fair. Get extra points for that. I'm going to be following you around, Garrett. Yeah. No, him. Are you going to the career fair too? Yeah. Okay, I'm going to follow both of y'all around. I'm going to be like, no, I'm just kidding. Thursday, the career prep assignment, make sure you read that and get started on it. It's a semester-long thing. You wait till the end of the semester, you will be sorry. Have you looked at it yet? All right, make sure you look at it. And make sure
it's called career prep.
That's all we did last week. There was just one assignment, but it's due in stages. So you need to watch the video because we had people from the Career Center here that explained everything you need to know.
And that's why we need to go to the career fair.
You don't have to, but you can if you go. If you just walk through it, and then you can come see me Thursday and tell me some things about it. I'll give everybody extra points. Even if you're not talking to anybody, I just want you to walk through it and see who's there. It's now. Yeah. So there's no reason. I mean, you're going to be walking through it anyway. All right. Okay. Got you.
Also, what proof do you have that like we went to the career fair?
You're going to have to talk to me about it.
Okay.
Like, have you already been? Okay. On Thursday, I'll just say, tell me about it, and I'll be able to tell whether you won or not by what you tell me.
Okay.
Right? I may ask you who you talked to and things like that. Yeah, we'll see. Good luck. Are you looking for anything in particular, or are you just getting points?
I don't know. Something in the accounting field.
Nice.
Because I live in Columbus now, so I don't want to go to Atlanta.
Gotcha.
So it's either go to a firm in Columbus or online.
Okay, this is great for you then. And you were here Thursday, right? So you heard Laurie talk about that she gets calls for accounting people all the time. All right. So you need to make sure you know her and she knows you.
Yes, I have my resumes.
Yes. All right. Way to go. Proud of you. Good luck. Keyshawn's here. Soraya's here. All right. I'm ready to get out of here. It's hot.